Inizio, prof.
Sì, sì.
Okay. Welcome all to the sixth session of our conference devoted to explore the new challenges to human rights protection. So first of all, let me express my deep sense of gratitude to the president of Italian Association of Comparative Law, Professor Zeno Zenkovic, who has made concretely possible the organization of this rich and outstanding program. Secondly, let me give to all of you, to all the members of the directive board of our association, to all the speakers, participants, and attendees, the same warm welcome I would have given if this event could be celebrated in presence in Perugia, in the spaces of my university and my Department of Law. Now, for our organization, we have 5 panelists in the morning, and I'll introduce you by simply mentioning the title of your papers. So I would ask you to present yourself briefly, so a position, a method of research, and graduation. For your presentation, you have about 20 minutes, and a session of question and answer will follow each presentation. As you know, those who are interested to raise a question or to make suggestions have to click the hands on command if participants, or if attendees have to write the comments on their proper notes field at the bottom of the screen, or simply they have to speak by unmuting their microphone. Now, before starting answering to my interdisciplinary vocation and trusting in the potentialities of legal imagination, I'd like to put on the table of our discussion as a sort of inspirational motive a fictive dialogue between a legal scholar and a poet. The legal scholar is Kostas Doudzinas, and he is pondering over the substantial consistency of human rights. He is noting, and I'm quoting from his wonderful, ever wonderful, Human Rights and Empire 2007. Human rights have only paradoxes to offer. The paradoxical, the operatic, the contradictory are not peripheral distractions awaiting to be ironed out by the theorists. Paradox is the organizing principle of human rights. The respondent poet, but even an eclectic man, is Archibald MacLeish, who participated in the founding of the United Nations and its Commission on Human Rights, and helped drafting the preamble of the United Nations Charter and the preamble of the Universal Declaration of Human Rights. And in my mind, he is echoing Doudzinas' words with the introductory riddle placed before the first lines of his brilliant poem Act 5, devoted to understand the sense of the duty and the sense of the right, and to supersede the anguish for certainty with the unredeemable force of ambiguity. And he is saying that with no one to whom the duty could be owed, and still to owe the duty, no one here or elsewhere, even the noble image of ourselves in which we trusted is broken and destroyed. And then he versified a modern history of a king enthroned and a god departed. It was 1948. But once again, even today, when we are talking about human rights, the question is, who shall play the hero part in the piece of law? So we can start, and the first speaker of the morning is Federico Delfino from the University of Genova, and Federico is talking about conceptualizing Russian and Hungarian illiberal fashion, affinities and differences in legislative implementation. So Federico, the floor is yours, please.
Hello to everybody. Thank you for organizing this conference also online, because most of conferences has been canceled, but this is a good chance for us to talk about our projects. So thank you very much. Well, I'm PhD candidate at the University of Genova in public comparative law. I'm going to hand my PhD next October, and my PhD research concern the Russian democracy, Russian democratic system, so-called, and the role of political parties. But I have to say that the project partially changed because, as maybe you know, last January, President Putin decided to change the constitution, so I have to add more things to my research and to recalibrate to some extent. So my article, the article that I proposed, analyzes the concept of sovereign democracy in Russia and illiberal Christian democracy in Hungary, which coincided with the presidencies of Vladimir Putin and the government of Viktor Orban, respectively. These processes seems to show similarities, not only in conceptualizing their illiberal ideas, but also in the legislative implementation. For this last part, I only have written down some ideas. I have already analyzed the Russian legislation because it's part of my PhD thesis, while I have had some difficulties on the Hungarian one because I should have gone to Budapest University to collect some materials, but due to the COVID-19 emergency, I could not, so this part is more work in progress. And then I will split my presentation in 4 parts. On the first one, I will make an introduction on some key concepts, but very, very quick, because I think that everybody here knows what a liberal democracy is, so I don't want to focus on that. Then in the second part, I will focus on the Russian sovereign model. On the third, on the illiberal Christian democracy in Hungary, and then I will try to propose you some conclusions that I found. Well, liberal democracy is the most common way of labeling the form of government that has long prevailed in the United States and in Western Europe, and that since the mid of the 70s, many countries in the world have tried to establish. It combines a democratic element and a liberal element. Very briefly, it incorporates characteristics of protection of individual rights, the rule of law, freedom of speech, assembly, religion, and so on. And so these values are generally considered as bulwark of democracy. Well, when in 1997, in his most known study, The Rise of Illiberal Democracy, Farid Zakaria affirmed that democracy is flourishing, constitutional liberalism is not. It was considered as an hazard, but today we can say that this statement was forward-looking. The collapse of the European communism accelerated a growing global trend that considered the liberal model universally desirable. Zakaria, however, intended democracy to be a negative term, a mark of failure. It designated countries that had initiated a transition way from authoritarian rule and had adopted free election, but had failed to build the liberal institutions. The only for the author that could grant the safeguard of individual rights. Today, illiberalism has become a banner that political leaders proudly fly. Well, while in the past, European countries matured from, the pattern was from illiberal into liberal, today, I think that it has partially inverted, and Western liberal democracy might prove to be the final destination of the democratic path. Well, and Eastern Europe has begun the laboratory for liberalism. In my opinion, Russia and Hungary and maybe Poland represent now the most evident example of this illiberal triumph. So, the Russian notion of sovereign democracy, in Russia, Sovereignaya Demokratia, has been for the first time publicly exposed in 2006 in a speech during a gathering of the political party Yedinaya Rossiya, which is the presidential party, United Russia, by Vladislav Shurkov, who was the chief of the Russian presidential administration. At a constitutional level, we have similar ideas, which are supported by Valery Zorkin, who is the chairman of the Constitutional Court of the Russian Federation. In several speeches, in particular recently, Zorkin expressed his nationalist and conservative position to counteract Western criticism concerning the Russian failure to adapt to the democratic standards. And he also led the court towards an anti-liberal direction. Sovereign democracy in Russia is strictly connected with the action of its leader, Vladimir Putin, and to the path initiated by the president after the Yeltsin chaotic era. And is based on the necessity of stability. Everyone who studies the Russian system know how important is stability for the system and for the people of Russia. In Shurkov's idea, sovereign democracy is consistent with the provision of the 1993 Constitution, the Yeltsin Constitution, according to the Article 3.1 in particular, that assert that sovereignty belongs only to the multinational people of the Russian Federation. From this perspective, Russia wants to emancipate and break the ideological dependence on Western theories. Ideological justification of the Russian model implies that the protection from the criticism of the West is necessary. And the Kremlin sovereign democracy is not a passive concept. It embodies the nostalgia of the USSR, the power of ideological attraction of the communist state, and the soft power so is an essential part to allow Russia to return to the world stage that had before. 13 years after the consolidation of the Putin regime, Shurkov published a very important article on a very popular Russian newspaper, Nezavismaya Gazeta, where he reaffirmed the achievement of the Russian President Putin and the new perspective for the country under the sovereign democracy. Since Putin has assumed the presidencies with a brief break of Medvedev from 2008 and 2012, it's under debate if it was a real break. I think it wasn't. Russia stopped collapsing and started to recover and to return to its natural condition of growing nation, a new typology of state that never existed before. The new Russian national model has proved to be a political functioning system in the past, but also for the next decades, for the future. And from Shurkov, Russia in its history experienced four main models of governance. The first one was Ivan III during the Kingdom of Moscow. The second, the government of Peter the Great, the Russian Empire. We are in the 18th and 19th century, the government of Lenin, so the Soviet Union, and now the government of Putin, the Russian Federation in the 21st century and in the future. It implies that sovereign democracy is designed to be a long-lasting model. Currently, sovereign democracy is able to influence Western ideology, restarting to produce and generate ideas to compete with Western ones as in the past. The system is based, very shortly, is based on a direct relationship between the leader, which is the president, and the Russian people. In the system, all the institutions are subordinated to this main task. The various branches of the government are centralized on the person of the leader, and these features well embody the traditional idea of power in Russia and the power vertical on which Putin's system is based, that has its roots in Tsarism and in communism, of course. For Putin, the liberal idea, in fact, outlived its purpose. And Western countries are now admitting that some elements of the liberal idea are no longer tenable, such as the multiculturalism. The idea has tried to overshadow the culture, the tradition, the religion, and the values of most of the population, making the liberal idea now obsolete. Traditional values are, for Putin, more stable than the liberal one because they avoid the risk of instability. Anyway, Putin's stance does not imply that liberal ideas must be destroyed. Rather, despite its right to exist, Western countries should accept the fact that it is not the absolute dominating factor. Well, so if Putin's idea was to export sovereign democracy, I think that it partially found breeding ground in Hungary, where the kinship between the Russian adjective sovereign and the Hungarian illiberal seem evident. Ideological criticism of Orban allows him to present himself as a European champion of traditional values, an idea that Putin previously discovered. Orban took the power thanks to the scandal of the ruling Socialist Party in Hungary, and also thanks to the country's disproportionate electoral system, to be honest, and its coalition was also took the power in 2010 and then was re-elected in 2014 and 2018, always under the leadership of Viktor Orban. When the concept of illiberal democracy was introduced in Hungary, The first time was during his famous speech held in summer 2014 in a small village in Romania. This small village has the characteristic to be in Romania, but with a high percentage of Hungarian minority. And Orban, in 2014, openly broke with a Western liberal paradigm. He declared its project of illiberal democracy deliberately against the liberal scheme affirmed in Western countries. Rightist Orban theorists, the most famous is Andras Lanci, considered the period between 1989 and 2010 as post-communist, according to which in 1989 there was no rupture. Both communism and liberalism are understood as failed projects of modernity, which reinforce each other dialectically. They claim that post-communism is best understood as the continuation of Marxism by arguing that communism and liberal democratization are two sides of the same coin. So, in declaring Western liberalism and individualism alien to the country, with an authoritarian and collectivist political culture and economy, Orban claimed a centralized, strong, paternalist state. And he emphasized that the new Hungary should be based on the labor. The labor-based system has excluded segment of the society, which are seen as unproductive, for example, poor and Roma. Well, although Orban party was initially inclined to counter-charge that it was ruling in an illiberal fashion, at some point Orban decided to accept and to embrace the idea that its party had turned against liberalism. It took the successful example of Singapore, China, Russia, and Turkey as non-Western and non-liberal, and perhaps not democracies. He affirmed that a democracy not necessarily have to be liberal, because a state is not liberal, it can still be a democracy. Furthermore, he underlined also that the new state is constructing in Hungary is an illiberal state. On July 2018, at the same venue where he held this speech in 2014, Orban again openly expressed his support for a liberal democracy, contending that there is an alternative to liberal democracy, and it's called Christian democracy. Christian democracy is the evolution of the illiberal democracy in the Hungarian way. However, he underlined that the aim of the Christian democracy is not to defend religious articles of faith, instead that Christian culture must be protected, including the human dignity, the family, the nation, because the Christianity seeks to preserve nations. He insisted on the fact that Christian democracy is by definition not liberal. In his argumentation, he emphasized three main features of this Christian democracy. First, liberal democracy favors the multiculturalism, while Christian democracy gives the priority to the Christian culture. Liberal democracy is pro-immigration, while Christian democracy is anti-immigration. Liberal democracy sides with, we can say, adaptable family models, while Christian democracy rests on the foundation of the Christian family model, the traditional family model. Well, to conclude, I want to say that some characteristic of the Hungarian Christian democracy worldview are indeed reminiscent of Putin's sovereign democracy. Nevertheless, in my opinion, there's not a clear evidence for see them copy and paste from Russia, because neither Russia nor Hungary seems to follow a clear ideology. Both concepts show a strict dependence from their leaders, and Orban and Putin personality are crucial elements for the system that they directly implemented. In fact, Orban and Putin excluded no leaders since emerging in both countries to continue their framework. So probably this model depends strictly from their leaders. However, if we follow an historical sequence, it emerged that a more pronounced rhetorical embracement of Russia by Hungary has followed the EU criticism of the diminishing democracy in Hungary. Russia was at the same time criticized for similar issue by international organizations. the sovereign model, the sovereign democracy doctrine was an ideological backdoor, allowing Russian authorities to rebuke any criticism of democratic norms violation by pointing the special non-Western ways to Russian democracy. Like Putin, Orban tries to market his political project internationally, and unlike Putin, he has an immediate access to the European political institution. Illiberalism, in fact, has a powerful appeal to those in the West, in Western countries who fear about global migration. Take for example, the Italian case of the Lega, or in other countries like France, the National Front, for example. The Hungarian government was particularly receptive to the Russian influence when carrying out its illiberal reforms. Based, in fact, on a supermajority after the 2010, the Fidesz party, so the Orban party, started installing a political regime that can be seen to share some characteristic with contemporary authoritarian regime, including Russia. And the increasing embracement of authoritarian great powers by the Hungarian government was not based on ideational proximity, rather than it was preceded by the growing alienation of the country with the EU. And it gave little space for Hungarians to find other allies. So they looked more and more to Russia. Well, to conclude, I think that similarities could emerge from an in-depth analysis in the implementation of policies and constitutional reforms. Hungarian financial nationalism has meant reserving the pension privatization, abolishing the independence of the central bank, nationalization of strategic sectors such as the banking, energy, and other public utilities. During the first period of its governance, Fidesz approved a new constitution where he eliminated a large part of checks and balances, weakened the parliament prerogatives, challenged the independence of the judiciary system, installed a very controversial control over the media. The pattern shows substantial similarities with the path of political and institutional reforms in Putin's Russia, such as the reform of the electoral law, the control over the constitutional court, the legislation on the media, and the law against the NGOs. So, if there's no evidence of mutual influence between the two ideologies, I think that similarities in political implementation could emerge, showing a clear path of mutual contamination between the two countries. Thank you.
Thank you so much for your inspiring paper. So are there questions, comments, suggestions? I don't see hands on. Yes, Professor Zenkovic, please.
Yes, just to understand, because I think this is a very important topic among comparatives, and I think this is an issue that we must discuss. I personally feel that as comparatists, as from a methodological point of view, we cannot expect that certain legal models, and constitutions are legal models, can be simply exported and transplanted. It makes really no sense. This is the problem with constitutionalism and let's say liberal democracy. I mean, I don't know if there's anybody who can certify that I'm liberal and I'm democratic, but I feel so. But at the same time, as a comparatist, I don't think that this one size fits all. And therefore, I think that the main issue of us comparatists is saying, well, what fits very well, let's say for Switzerland, Italy, Spain, or Sweden does not go with Russia. I remain with Russia because obviously Hungary, as you pointed out, has other constraints which are it's belonging to the European Union. But I mean, is this something that we as comparatives, not as preferring one or other ideology, I quite agree, I mean, on the notions of I would not like to live in Russia, quite happy living in Western Europe. But do we think that this model is that sort of liberal democracy is fit for Russia, or it is fit also for China? I mean, the whole issue of so-called output democracies, where you don't look at the procedural democracy, you don't look at the input, but you look at output. So what is satisfied by the state? And also, I think that this issue is, I mean, personally, I was knowing that part of the world quite well. I mean, I was very doubtful about the whole rhetoric about the sort of the Arab Spring, which showed that sort of this idea of transplanting democracy in Northern African and Middle Eastern countries makes very little sense. So just wanted to see from your point of view as a comparatist, I'll just remain on Russia because I repeat, do you think that this is something that Russia has nothing to teach us comparatists on sort of how the forms of state and how the modern states could work?
So would you add something to clear?
Okay.
Federico,
should we wait others or okay? I answer directly to the professor. Yes, I think you're right. Because I have to focus more on the input. Yes, I totally agree. I don't think that Russia has something to teach us, but I think that we should better understand Russia and its characteristic. I think that if we analyze Russia with our criteria, we cannot really understand the Russian model. Because the past the Russian past is totally different if compared to our past. And if you ask to Russia, and there are some surveys that testify this point of view, if you ask Russia, are you living in a democratic in democracy now? They almost all they answer yes. Yes, because they have elections, but we know that elections are not a sufficient element because they can go to the supermarket, they can do almost whatever they want. So I think that you're right that we have to focus more on the input rather than on the output as comparativist. But when I decided to write this paper, I was inspired by the influence that Putin is going to have and the Russian model is going to have to our Western parties, in particular to nationalist party. So I think that I have to rearrange a little better my paper. So thank you for the consideration.
So there are also comments or suggestions by Professor Monateri and by Antonia Baraggia. Please, Professor Monateri.
Okay, thank you. Two things. First, don't you think that the term liberalism is now too worn out and ambiguous to be used for scientific discourse? I mean, well, I understand very well that liberalism is a common term in political debates, but I really doubt that you can find something out from using liberalism, especially because it has such two opposite meanings on the two sides of the ocean. I mean, it is, of course, true that in America, liberalism is a term denoting the left wing, and in Europe, the right wing. So how can a comparatist cope with a term from a scientific purpose that has such opposite meanings? I would certainly not be a liberal in the United States, and So I think you should avoid any reference to it. And also the idea that we know what democracy is. Well, do you think it is the same to protect freedom of speech, reserving the protection to the statute, to legislation, like in Italy, or to state, like the First Amendment, that the Congress shall not pass any statute about religious matter and freedom of speech? They are two opposite models, two opposite models. And when you say, we know what democracy is, we know that democracy, the parliament and the election are not enough to define democracy. How colonial you are. How can you be so colonialist? I mean, we know what democracy is. We, the Westerners, the West, those small part of the West, which is Europe, and maybe the semi-left of Europe, we know what democracy is. This is totally colonial, I mean. How can you combine being maybe so good-oriented towards other cultures and then state, we know what democracy is, and you do not live in a democracy? Those are my 2 points. Thanks.
So please, Federico.
Yeah, okay. Yes, this is the one of the most hard thing to answer, especially your first question. Yeah, because I think there is a huge literature about that, starting from Kelsen, and yeah, I have to challenge with it. You're right, but you know, as comparativists, we have to find some definition. Start from this definition. Could be right, could be not right, but we have to try. So I start from the classical differentiation. So liberal democracy, this is the liberal democracy. I start from this concept and then I compare. I cannot do in another way. It's right. If I am American, I cannot understand what you are saying. If I am Chinese, you can say that I am a colonialist, right? Also, and this is a very hard problem for me I study Russia, the Russian system. But I have to find some definition, and starting from this point. It's very hard. You're right, of course, but we need to categorize in some way. And in the second question, I think I don't know how to answer, because starting from the first question you posed me. Freedom of speech, freedom of religion, and other freedoms that we call classic freedoms are not considered classic in Russia, for example, or in China, or maybe now in Hungary. And so we have, to some extent, also consider this point of view. It's very hard, in fact, to compare the Hungarian system and the Russian one, because Hungary is part of the European Union. But now the question is how European limitation, how European rights matter for Hungary. Are they respected? I don't think so. So I think that and this is why I decided to compare, because Hungary is going towards Russia rather than towards European Union. And also because they have a common communist past, so they influenced the current debate on these rights.
So there is another question from Antonia Braga. Please, Antonia.
Thank you. Yes, I have 2 questions and comments related also to the issue of categories, because one of the, I think, most interesting categories that has been used to describe the Hungarian situation is the term abusive constitutionalism by David Landau. And so I was wondering whether you consider this category of abusive constitutionalism also for the case of Russia. This could be, I think, a useful frame to look at the two cases in comparison. And secondly, there is a comment about the different path taken by Russia and Hungary, because as you already said, Hungary at a certain point entered the European Union, and during the accession accepted the basic principle of the EU, the rule of law, democracy, and so on and so forth. So it's completely different from the Russian path, but there is an interesting literature about this. Andras Jakab, also Shayo from the Central European University, they claim that when the Hungary acceded the European Union, they did so without a proper constitutional moment. So was just a superficial commitment to EU values, while the legal culture remained completely linked to the socialist past. So I think this also could be an interesting approach to look at the different comparison between Russia and Hungary.
Yeah, thank you for the suggestion and for the literature. As I said in the introduction, I had no chance to go to Budapest University to focus on this on Hungary. So I worked on a distance, but I will do in the future, of course. And yes, I think that communist past in Hungary matter. That's true, but when we think about Hungary, we have also to think that it was part of the Habsburg Empire. So. And it has also a democratic experience between the two wars. It was one of the most evolved countries in the Eastern Bloc. It was, of course, the Hungarian and Polish communism were, to some extent, most liberal, most evolved, rather than Romanian one or the Bulgarian one. So. I don't think that the socialist past matters so much as it matters for Russia. So it creates obviously a problem when comparing the two systems. So I think that this is a very important problem, a very narrow issue, but. From another point of view, I think that the relation also with the European Union is very complicated, but it became complicated when Orban took the power, because during the first years, Hungary was one of the most relevant examples of success of liberal democracy. Everything changed once Orban took the power. So this is, in my opinion, the turning point. Because before, Hungary was a champion of, with Poland and with Slovenia, a champion of democracy, rather than Bulgaria and Romania, that now, for example, are performing better than Hungary and Poland. That's a paradox. But yes, of course, I think that the dimension that you mentioned is very important to focus, and I will do that. Thank you for the comments.
So thank you for this lovely discussion, and you can move to the second speaker. The second speaker is Petros-Orestis KATSOULAS from Université Panthéon-Assas, and he is talking about public entities as holders of fundamental rights, theoretical utopia or legal reality, a comparative analysis. So Petros-Orestis, the floor is yours.
Thank you very much. First of all, let me introduce myself. I'm PhD candidate at the University Panthéon-Assas. The topic of my thesis concerns the use of comparative law by the European Court of Justice and the Supreme Court of the United States. But I've mainly focused on the administrative law because I'm a public law comparative. Well, now, starting on the topic, commenting on a decision of the French Council of State, the professor of public law, Léon Blum, in the beginning of the 20th century, had argued that it was difficult to accept that the legal personality of public law, which has been created by the state and can only act under the state control, could be assimilated to private owners who could claim the property against the public power itself. For Georg Jelinek, legal persons governed by public law cannot be autonomous since the state imposes an easement on them by obliging them to align their activity towards the satisfaction of the public interest. In this way, public entities appear as heteronymous institutions whose activity is seen as a mere extension of the central authority, as a simple execution of the legal provisions which have been set objectively by the central administration. This context is not reconcilable with the idea of freedom or self-determination upon which the liberal theory of human rights has been constructed. However, the emergence of the concept of legal personality questions the image of the unified state, according to which all competencies of public institutions converge. Indeed, since the beginning of the 19th century, the state started to be considered as a personalized legal entity, subject to the rule of law and founding its authority on a system of legal relationships. As Georg Jelinek again points out, the state can no longer be grasped abstractly in an inorganic way, but it exercises its action within a system in which institutional relations prevail. Indeed, through the notion of legal personality, the various groups and individuals started to be regarded as autonomous legal subjects, capable of entering into legal relationships, opposing their interests to any disproportionate or illegal governmental interference. Thus, the very existence of the legal personality led to the recognition of a sphere of autonomy within the legal order, although this autonomy is exercised in a restrictively defined framework. On the other hand, the very concept of fundamental rights has gradually diverged from a purely humanistic dimension and has been seen as a basic element of the constitutional or supra-constitutional rule of law, which establishes a system of protection for every legal person recognized by legal order, be it national or international. Although according to the classical liberal tradition, only natural human beings can be bearers of fundamental freedoms, legal positivism has contributed to a more objective interpretation, making judicial persons potential holders of such freedoms. The reasons for this semantic transformation find their roots in the progressive recognition of legal persons as subjects of law, a theory expressed by Professor Brault in France, as well as in the crystallization of a more objective approach, which considers human rights either as objective values of the constitutional regime, that is the case of Germany, or as institutional guarantees that govern the whole function of the public administration, that is the case of France. Thus, according to some theoreticians, human rights are no longer linked exclusively to the principle of human dignity, but they can be also guaranteed as constitutional values recognized by the laws of the state, protecting each person considered as a legal subject. Throughout this presentation, we will proceed to a critical analysis of the conceptual problems that arise regarding the recognition of fundamental rights of public entities. The first part will focus on the various theoretical approaches offered both by legal doctrine and the jurisprudence in sub-European legal orders. And in the second part, we will adopt a case-by-case analysis by highlighting a list of the specific potential rights guaranteed by constitutional and administrative jurisprudence in Europe to some public entities. Part 1, towards the recognition of fundamental rights of public entities, limits and ambiguous considerations. The strong dependence and interconnection of public entities on the central power was the main conceptual element taken into consideration by the publicist doctrine since the beginning of the 19th century. Even with the recognition, however, of a more autonomous status and later a different legal personality, public entities continue to be considered as part of the administration. The fact that the activity of this institution is determined by the pursuit of the general interest seems neutralizing their legal status as subjects of law and making them appear always under the tutelary figure of the state. However, according to the French professor Ronald Rago, the idea of autonomy for public organization was not unknown under the old regime in Europe. Municipalities were comparable to the local inhabitants who recognized certain property rights. The gradual development of their activity within the sphere of a legal personality started establishing a totally new vision for the understanding of the administrative structure of the state based on their legal relationships and the institutional pluralism. Although their status cannot be absolutely aligned with the legal regime which is attributed to private legal persons, public entities as legal persons can dispose of a core of autonomy, which although is more... Yeah?
Can you speak slowly? Slowly.
Yeah, you're right. Thank you. Which, although is more limited and marked by the central authority, detains a part that can be identified as relatively free sometimes. Faced with this duality, the French theorist Maurice Aurieux was the first to speak of an objective individuality of legal persons of public law, which fluctuate between the objectivism as state actors and the subjectivism as legal person. Well, my first subpart of this first part is devoted to the subjective approach of Germany and Spain as an attempt to extend fundamental rights of public entities. Despite the admission of an autonomous sphere within these entities, the classical concept of freedom, which consists in doing everything that is not prohibited, seems difficult to transport to public legal persons in Germany. This idea is reiterated by the Federal Court of Constitutional Court of Germany, which questions the possible connection of the activity of a public entity to any idea of freedom, considering that these entities are attributed with powers whose content is precise and limited. For the German constitutional judge, every kind of discretionary power should not be assimilated to freedom as it remains in the field of administrative law. On the contrary, other theoreticians of the German school proceed to a distinction between two spheres of a public person. The first being that of their competence and the pursuit of the general interest, and the second, that of a particular autonomy, adapted to their nature. The subjective approach of the German doctrine, which defines fundamental rights as legal prerogatives, protecting human beings against any interference from public power, could explain the reluctance to recognize public entities as holders of such rights. For the Federal Constitutional Court, legal persons only in some cases can they be regarded as bearers of fundamental rights when their activity is an expression of the free development of private natural persons, in particular when their mediation appears necessary in order to give full meaning to the free development of the natural persons who remain behind them. This is why the court highlights that when a private legal person performs a public function, it cannot claim any fundamental rights. Despite this human-oriented approach, Professor Betterman has claimed that the Article 19, paragraph 3 of the Basic Law of Bonn, which provides that the basic rights are also applied to domestic moral persons to the extent that the nature of such rights permits so, should not be limited only to legal persons of private law, but also to public entities. Although such an idea is continuously rejected by the Constitutional Court, an exception is made for a certain type of legal persons governed by public law that present a greater degree of autonomy, always on condition that such an entity does not perform a public function. Indeed, churches, which are governed by public law in the German legal order, have been recognized as capable of invoking Article 4 of the Basic Law of Bonn relating to the freedom of conscience. For Professor Achterberg, there can be cases in which a public organization can be in a situation of submission to another public entity, being in a position similar to that of any private individual. On a similar basis, the Spanish Constitutional Court considers legal persons of public law as potential holders of fundamental rights when their purpose is to defend certain areas of freedom of human beings, or when it is only through them that fundamental rights of individuals can be claimed. As the court has pointed out, in the same way that collective persons are legitimated to defend by substitution the rights of their members, so public administration can also appeal against those decisions of the courts that allegedly violate fundamental rights of the population they represent. It was in that vein that the court has ruled that the universities are bearers of the right to autonomy. Besides, the analysis of the case law of the Spanish Constitutional Court reveals that any potential reference to fundamental rights of the public entities is made under the notion of the legitimate interest to access the court as provided by the Article 162 of the Spanish Constitution. This is why, as Gomez Ferrer Moran points out, public legal persons may be considered as bearers of fundamental rights if and only to the extent that they can find access to the court. Nevertheless, the concept of legitimate interest is broader than that of subjective rights, so we cannot assume that the Spanish constitutional legal order explicitly considers public entities as holders of these rights. For José Manuel Díaz Lema, the legitimate interest of Article 162 introduces a triangular relation where the judicial persons act only on behalf of the individuals whose interest it represents, the real bearers of fundamental rights being the represented individuals. On the other hand, Serna Macia suggests that fundamental rights can be invoked by public judicial persons when they act in the field of private law. This is a theory also supported by the German doctrine, but not by the Federal Constitutional Court itself, which considers that the administration can never be in the same situation as individuals. In the same spirit, Jiménez de Cisneros, based on two decisions, which extended the protection of Article 24 of the Constitution to the autonomous government of Navarra, considers that public legal persons can equally be holders of some fundamental rights, especially when they act in the field of labor law. The objective approach of France. On a different basis, the French doctrine adopted an objective approach of human rights, considering them as constitutional standards that prevail due to their hierarchically superior status. Based on this substratum, the French judge was able to see public legal persons as potential bearers of the constitutionally recognized rights. As an illustrative example, the French Council of State has recognized the possibility of a public moral person to invoke the infringement of the rights and freedoms guaranteed by the Constitution, such as the property right, guaranteed by the Article 2 and 7 of the Declaration of the Rights of Man and of the Citizen. Besides, the French Constitutional Council has also accepted the invocation of individual rights by public entities. A similar logic can be traced also in the reasoning of the Court of First Instance of the European Union, which has ruled that an autonomous entity enjoying legal personality is capable of bringing an action seeking to protect its rights. Here echoes the objective approach, according to which the infringement of a fundamental right can involve the launching of a jurisdictional procedure and allow the invocation of the right by any legal person subject to the state. Speaking of the European judge, it's worth mentioning also that the member states themselves are legitimated to invoke fundamental rights before the judicial bodies of the Union, as ruled by the European Court of Justice in a decision of February the 12th of 1992, which confirmed member states' ability to invoke fundamental rights, giving a particular emphasis on the right of defense. Remaining at the European context, the European Court of Human Rights has shown a more reserved attitude towards the application of the Convention to entities governed by public law. Based on the restrictive wording of Article 34 of the Convention, the Court consistently considers that local authorities are deprived of the right of access to the court. In a 1995 case, the European Commission of Human Rights considered that where there is a decentralized distribution of power, any national authority exercising public function is excluded as an applicant. Gradually, an irrebuttable presumption seems to have been set by the court, which constantly denies the status of applicant to organizations that consider as governmental. Nevertheless, it may happen that the court considers a public entity as non-governmental organization within the meaning of Article 34, and thus bring it under the scope of the Convention. Its case law shows that the most relevant criterion for the court is the absence of public law prerogatives. Examples of religious public entities which are considered as persons of public law by national legislations confirm this orientation. In a 1996 case, the European Commission of Human Rights, for example, agreed to take up the plea of a parish which alleged a violation of the right to freedom of religion, while in the Radio France case, the court ruled that the national company Radio France, despite being under the supervision of the state, was a non-governmental organization since it did not exercise the prerogatives of a public authority and presented editorial independence and institutional autonomy. In the case of holy monasteries against Greece, the court used three cumulative criteria in order to rule on the admissibility of the request of the Greek monasteries, which denounced that the transfer of part of their regal property to the state violated the right to property. The court held that despite being attributed a legal personality of public law, the monasteries pursued essentially spiritual and ecclesial objectives, they did not exercise any prerogatives of public power, and they were not subject to the state control. My second part is devoted to the identification of fundamental rights that public entities can hold. I will be more brief here for time economy. Well, as far as substantive rights are concerned, we can find examples by the French jurisprudence protecting the name, the logo of a municipality or other public secondary public entities, while the Court of Cassation has also ruled that the public person is also like to find itself protected in the context of defamation. Besides, it's on the basis of freedom of administration that local authorities, that the French Constitutional Council has, such as the university or municipalities, that are recognized with economic freedom, such as the contractual freedom to contract. And also which implies the prohibition of any obstacle brought to their economic activity. As far as universities are concerned, the French Court of Auditors has also accepted the budgetary economy, while territorial collectivities are also granted the capacity to use financial means for the realization of their local affairs, which is enshrined also in Article 3 of the European Charter of Local Self-Government, which guarantees the right of local authorities to regulate and manage their public affairs. As far as the right of property is concerned, in general, public property was for years oriented towards the satisfaction of public purposes and has followed a state-oriented logic, especially in France, but in other countries too. However, the French Constitutional Council, in its decision of the 21st of July 1994, ruled that the provisions of the Declaration of the Rights of Man and of the Citizen relate to the right of property.
Sorry, Petros, you have 5 minutes to conclude.
Yeah, I'm finishing. Relate to the right of property concerned not only private persons, but on an equal footing their property of the state and other public persons. While the French Council of State has criticized the absence of compensation for the transfer of property from one municipality to another on the basis of the first additional protocol of the ECHR. Now, for procedural rights, there we can find a more tolerable approach by their jurisprudence. For example, since the beginning of the 19th century, the French Council of State had considered that the right of access to the judge is an indispensable right in order for a municipality to assert its claim. While the European Court of Human Rights itself has ruled that any legislation which would deprive a public person qualified as a non-governmental organization in the meaning of the convention would violate its rights and undermine the very substance of the right access to the court. We can also find examples of the lack of publicity of the hearing sanctioned by the Council of State, of the French Council of State, while the Spanish Constitutional Court has also adopted a more tolerable approach regarding procedural rights, ruling that the right to the effective judicial protection corresponds both to natural and legal persons, and among the latter, both those governed by public and private law. To conclude, and I can answer 2 questions, considering public entities as holders of fundamental rights still remains a theoretical construction. The conception of fundamental rights as part of human dignity remains a key component of the judicial thought. And on the other hand, the absence of a clear and comprehensive recognition of fundamental freedoms to judicial persons in general prevents a more legalistic approach. In countries that remain attached to the human-centered approach, any recognition of fundamental rights to legal persons governed by public law is made by direct reference to the natural person, the legal personality of the public entity playing a secondary role. However, entities remaining far from the core of the state power and whose status resembles private individuals are treated in this legal system we have examined with much greater tolerance. This leads us to the conclusion that the basic conceptual criterion is not so much the characterization of an entity by domestic law, but whether it is attributed with powers of repression and participates in the exercise of public power. And in order to add my last phrase, if we focus on the legal evolution of the status of these entities, or the fact that on the network of the legal relationships they participate in the evolutionary dynamic of the concepts such as property and administrative autonomy, I think that we can see in the future a more tolerable approach towards the recognition of fundamental rights to some entities that resemble private actors, maybe. Thank you very much.
Thank you, Petros, for this dense effort, conceptual effort in presenting the keepers and the mutable phases of the keepers of the human rights. So, are there questions, suggestions, comments? I don't see anyone. So there are no questions? Yes, Professor Monetti, his hands with his hands.
Yeah, yes, just not to leave the speaker alone. I mean, because what is said is really important. I presume that especially before modernity, in Middle Ages, I mean, municipalities have been the major issue of the birth of legal personality. I can remember that Bartolus wrote extensively on free cities. And indeed, the idea that a body of citizens can have a corporate body started with municipalities. So it is almost strange that this fact that, first of all, free cities having a corporate body became so underwent in modernity, and especially in French law. It was really a cornerstone of the Ancien Regime, the fact that cities had a personality. So I'm rather intrigued in your story. And I think there is an area plan which really deserves to be investigated. Thank you.
Well, thank you very much for your comment. That's indeed is that, as you say, that is on the old regime, we can find that the group, the collectivities are recognized with some kind of autonomy, some rights. A tradition which breaks with the French Revolution, where we can find that the individual person becomes the center of the protection of fundamental rights. And then this, the Enlightenment tradition, and this passes in Europe. But I think that even if we look at the Spanish jurisprudence, even the Italian jurisprudence, I think, the German jurisprudence, I think that we can find this more tolerable approach to municipalities in comparison with other public entities that are more close to the public administration and that are really cannot easily be recognized a more autonomous status. They are identified with the state itself. I think this is important, and this is what I saw from my research, from my comparative research that I conducted.
So thank you all. And the next speaker is Karmen LUTMAN from the University of Ljubljana. And Karmen is talking about disenrichment defense through the prism of human rights. Please, Karmen, the floor is yours.
Thank you, Professor, and good morning to everyone. I'm dealing mostly with private law and also with private comparative law. Last year, I defended my PhD dealing with the law of unjustified enrichment from comparative perspective. And now I'm developing this topic and comparing it or finding interactions with human rights. So in my presentation, which I would like to share with you on the screen, if I may. Is it visible to you?
Yes, perfect.
Okay, thank you. So in my presentation, I will address the relationship and the interaction between fundamental rights and the law of unjustified enrichment, which is in most legal orders recognized as a separate source of obligation apart from contract and tort. More precisely, I will focus on disenrichment defense, which is in common law also known as change of position defense. which is a defense recognized in the law of unjustified enrichment, and I will analyze it from a human rights perspective. Namely, it can be seen from the recent case law of the European Court on Human Rights that disenrichment defense, as a manifestation of a protection of legitimate expectations, has also a human rights dimension. So my presentation is divided in two parts. In the first part, I will briefly present the disenrichment defense and its role in private law. And in the second part, I will analyze it from human rights perspective, which might be interesting also for those countries who do not recognize disenrichment defense in their law of unjustified enrichment. I will also try to answer the question whether and to what extent disenrichment defense is to be treated differently in private law and in public law. So whether there are some differences between this defense, if this defense is invoked in a horizontal relationship between two individuals or in a vertical relationship between a state and an individual. So to start with first part and to deal with disenrichment defense as a private law remedy, more precisely defense in the law of unjustified enrichment. So the law of unjustified enrichment creates liability in cases where one person is enriched at the expense of another, and there is no valid legal ground for retaining this enrichment. So for the claim in unjust enrichment, the claimant must prove that the defendant has been enriched at his expense and that this enrichment is unjustified. So if this is so, the law of unjustified enrichment imposes an obligation upon the unjustly enriched recipient to return to the impoverished party what he or she had received without valid legal ground. So this obligation is subject to various defenses, and one of them is disenrichment defense, also in common law known as change of position defense. And in my presentation, I will refer to both terms meaning the same defense. So according to this defense, the enriched party may claim that he or she is no longer enriched because he disposed of the object received or lost it or consumed it. And therefore, he might be relieved from his obligation to make restitution of the received benefit. So this disenrichment defense was in Roman law, it was not generally accepted, especially in so-called condiciones. There was no right to claim disenrichment defense. However, this the theory behind this defense started to develop massively with the influence of Panthéon-Assas doctrine in Germanic legal systems, and this defense was first codified in German Bürgerliches Gesetzbuch, called as Wegfall der Bereicherung, and also it spread to other European civil codes, for instance, Swiss Civil Code. Also, it was quite recently recognized in English law of unjustified enrichment, and also a few decades before also in American law. The philosophy underlying this defense in private law is to prevent the defendant from suffering a loss by being obliged to return the benefit which he is is no longer present in his assets. However, in private law, only a recipient who lost his enrichment in good faith, that he was entitled to it, can use this defense. The defense in private law applies in two cases and is distinguished between reliance-based disenrichment defense and non-reliance-based disenrichment defense. So the basic difference, the main difference between these two types of defenses is that in first case, in reliance-based disenrichment defense, the enriched party or the defendant claims that that he lost his enrichment because he lived in the belief that he is entitled to the object received and used it or disposed of it accordingly in good faith. For instance, if I give an example, if someone mistakenly received amount of money and spent it, for instance, by traveling abroad because he thought that he is entitled to this sum of money, he may defend himself with this reliance-based disenrichment defense and claim that he is no longer enriched and therefore he would be relieved from its obligation to make restitution. So on the other hand, just briefly, non-reliance-based disenrichment defense is used in cases where the recipients, where this disenrichment occurred independent of the recipient's reliance on his acquisition. For instance, if the object received was stolen or destroyed. So to sum up briefly, by using this disenrichment defense or change of position defense, the defendant can, in private law, claim that he is no longer enriched and he can be relieved of its obligation to make restitution. In this way, he can actually shift the burden of loss, subsequent loss of the object to the creditor, to the claimant. And therefore, it is then the creditor and the claimant who bears the risk of subsequent changes to the received benefit. And since such a broad interpretation of disenrichment defense is actually disproportionately in favor of the defendant and it could actually threaten a proper balance between interests of creditor and debtor, it should be interpreted restrictively. So taking into consideration all circumstances, all relevant circumstances of the individual case. Mostly one of the decisive factors is the good faith of both parties, especially the defendant, and also it is decisive whether this enrichment is in any form whatsoever may be still present in the assets of the defendant. For instance, if he received the sum of money and bought a car for this money, he's still enriched not for the sum of money but for the car. So in that case, he wouldn't succeed with this enrichment defense. So one of the prerequisites in private law to succeed with this defense is to prove that benefit in any form whatsoever is present in his assets. This enrichment defense, and this is also important to mention, that the philosophy underlying this defense is to protect the recipient's reliance on the validity and finality of his acquisition. So if he reasonably assumed that the received benefit would remain his and took various decisions in that belief, his interest in the security of the received deserves protection. And in German theory, this is also known as Vertrauensschutz concept. So it is, of course, in line with this rationale, with this philosophy that this defense protects only good faith recipients. So recipients who did not know and also could not have known that they were not entitled to the benefit received. So exempt from this protection are bad faith recipients and also those who are subject to so-called strict liability who due to already filed restitutionary claim. And this is actually also a linking point between the law of unjustified enrichment and human rights, because reliance on the definitiveness of the acquisition of assets also enjoys protection under the European Convention on Human Rights. Namely, it is protected by the right to property as enshrined in Article 1 of Protocol 1 of the Convention. So, according to the settled case law of the European Court of Human Rights, this right applies not only to persons already existing possessions, but may also in some circumstances protect a legitimate expectations of obtaining an asset. So this issue of limiting the right to restitution in order to protect the recipient's legitimate expectations of the definitiveness of received assets was also discussed by the European Court of Human Rights in its quite recent decision, Čekarewicz versus Croatia. This case concerned the applicant's complaint that she was ordered to make restitution of unemployment benefits that she had been receiving for several years in Croatia due to a mistake of unemployment bureau. When the state, after a few years, found out that there was actually a mistake a state made a mistake by ordering, prolonging her right to unemployment benefits, the courts decided that she has to make reimbursement of these unemployment benefits, and it was a sum of 2,600 euros. Mr. Čekarewicz then made a complaint before the European Court of Human Rights, and she said she was complaining that this right to restitution actually breaches her legitimate expectations. And the European Court of Human Rights decided that she has a legitimate expectation of being able to retain the funds received without her entitlement to employment, because she was actually misled by the state. It was a mistake of the state, and she was, as noted in the decision, that she was in good faith. And also, it took over 3 years for the authorities to react to their error. The court also took into consideration that she was unemployed, that she was ill and in a poor financial situation. And also, what is important from perspective of disenrichment defense, that she had spent the received money for covering her basic living expenses and therefore accumulated no savings. So the court noted that in such circumstances, paying the debt would threaten her subsistence, and also one of the crucial facts for this decision was that the state was fully responsible for the mistake, for the overpayments, and making her, obliging her to make restitution would mean that the whole burden of this state's mistake would be fell on her, and therefore the court decided that the right to restitution violated her right to protection of property. So in my opinion, this decision could be interpreted in a way that it acknowledges an individual right to raise disenrichment defense in circumstances where this right to restitution of a state could violate the individual's right to property. However, I'm well aware, and it should be pointed out, that this decision deals with a vertical relationship between a state and an individual, and also the European Convention on Human Rights indirectly applies to such relationships. So, and of course, in public law, also the traditional institutes of private law should be used and should be applied with a certain caution, also adapted to particularities of such relationships, since, of course, state and individuals do not interact with each other as free and equal agents. So, therefore, it is questionable to what extent change of position defense as applied in private law can be used in public law. And in many countries, this issue still remains rather unclear, including Slovenian law. In German law, for instance, the defense has been already recognized also in public law, but with certain modifications. For instance, it is acknowledged that individual can raise disenrichment defense against the state, while the state can never claim disenrichment defense against individual. In my opinion, it seems from the case Čakarevich that in contrast to, or in different from private law, where for raising this defense, it is important to prove a good faith, and as I said, that this overall disenrichment. But in public law, it seems that also it is important to observe whether it was a mistake of a state that brought actually this and that caused this enrichment of the individual. Only to briefly mention that change of position or disenrichment defense as defense of private entities against the state was already acknowledged by the CJEU, and similar as the European Court of Human Rights, also the CJEU held that this disenrichment defense is based on legal certainty and the rule of law, such as also legitimate expectations. So as we can see, the change of position defense or disenrichment defense as a primarily private legal defense has been, together with its main features developed in private law, also transplanted into public law as a manifestation of the principle of legal certainty and the rule of law. So to conclude, disenrichment defense, also known as change of position defense, is primarily defense against a claim in unjustified enrichment. So in private law, it applies in horizontal relationships between two individuals. It aims to protect the recipient's reliance on the validity and the finality of his acquisition. And since this reliance is also protected by the right to property, as enshrined in the European Convention of Human Rights, it can be considered that this defense has also human rights dimension. It should be noted, however, that convention has its direct effect in vertical relationships, protecting individuals before the state, and in such relationships, the change of position defense might be applied only in a modified version. Although case law of the European Court of Human Rights is rather scarce on this issue, it can be seen from the recipient it can be seen from the case law that, of course, also good faith of the recipient is important, but apart from that, that also conduct of the state plays an important role. So this concludes my presentation, and I would be grateful for any thoughts or comments you might have on this topic. Thank you.
Thank you so much, Karmen, for this interesting presentation. And it makes evident, I would say, the difficulties or the ambiguities in legal taxonomy. And it made me thought to a kind of a sliding doors that is open between the concept of property in European perspective and the concept of legal cause, which is the basis of the notion of unjust. And so unjust enrichment, of course. So there are questions, suggestions, comments from any one of you. I don't see hands on. Professor Monateri is handing on? No. So yes, there is Professor Zeno-Zenkovic, please.
Your presentation on a very classical issue. As you mentioned, the sort of the origin of the, I see you have a PhD in Berlin, and so therefore you're very familiar with German case law. I'd just like to point out that what is very important, that if you look at the first 15 years of the Reichsgericht jurisprudence, the first 15 years of the BGB, you see a flourish, an enormous amount of decisions on unjust enrichment. Why is this? Because of the very restrictive interpretation of paragraph 823. So as the parties who had been damaged could not resort to paragraph 823, well, they found what we called in Italy la Santa Rita. Well, you know, the last offense is that of unjust enrichment. So it's very interesting to see how this development of unjust enrichment in the first 15 years of the German jurisprudence then has influenced what happened afterwards. Obviously, this is much less relevant in post-Second World War German jurisprudence, because obviously it was the Constitution, and then the sonstiges Recht were obviously all the ones indicated in the Constitution. But just to point out how, well, I appreciate this historical background, because especially if we study private comparative law, we have to look at history and how legal institutions have developed. So just to point out that how I appreciated your presentation.
Thank you, Professor, for this comment. Yes, indeed, in German law, there was quite a huge expansion of the literature dedicated to the law of unjustified enrichment. Also because of this so-called Abstraktionsprinzip, which makes the law of unjustified enrichment even more used in practice, as for instance in other continental countries. German law was often also criticized due to a rather broad interpretation of this disenrichment defense. But in the recent decades, it seems that also they are interpreting this defense rather restrictively in order not to make the gates open for some maybe not very legal acting, or in civil law, in private law.
Just one thing, maybe now. Yes, anyway, under the BGB, the matter of unjust enrichment was strictly part of the law of obligations, I mean, part of the Litigation and Recht. Whereas here, I've seen and noticed a big shift toward property. And there was almost a ditch between the two ones. So is it true or not?
Yes, actually, I'm now in my paper trying to find this connection between right to property and disenrichment defense, especially because in a certain way, disenrichment defense also tries to somehow protect legitimate expectation that the asset which was obtained would remain forever in the defendant's possession. And of course, disenrichment defense enables to protect these legitimate expectations already required possessions. And this is somehow also, of course, linking point to the right to possession as enshrined in the European Court of Human Rights. Although decisions, there is no lot of case law on this issue, but still, I would like to somehow develop this thesis in this human rights dimension.
Thank you all. So we can move to the other speakers. So the next speaker is Çetin NESLIHAN, if my pronunciation is correct, from Sorbonne University. And Çetin is speaking about a state of emergency in Turkey and France, a comparative study of a utilization of law as a political instrument. So please, you have the floor.
Thank you, buongiorno, and thank you for this opportunity. I'm a PhD candidate in University of Sorbonne in Paris, and I'm working on the evolution of the rule of law in Turkey. And I'm trying to conduct a research, comparative research with the case law of the European Court of Human Rights. And now I'm going to talk about the state of emergency in Turkey between 2016 and 2018, and state of emergency in France between November 2015 and November 2017. Actually, my presentation is more about Turkey, but at some point I try to give some examples from the French model. I will try to begin with a brief introduction to my subject. The state of emergency designates an exceptional regime set up by a government in the event of a severe breach of public order, serious disturbances, or national calamities. Even if it is stipulated by law, the state of emergency is a parenthesis of the rule of law for the benefit of the maintenance of public order. In the Turkish Constitution of '82, the state of emergency is addressed in the Article 120, and in France, the state of emergency is framed by the law of 3 April 1955. A state of emergency is not always an exceptional practice in modern states. States can make it an integral part of normal law in cases where the crisis is linked to the concern for security. Furthermore, it is possible that in several situations, the practices of the state of emergency are implemented without the proclamation of the state of emergency. We can give as an example the periods in which the law is suspended to thwart a popular protest on the grounds of guaranteeing public security. We can give the example of the government's reaction to Gezi events in 2013 in Turkey. Fundamental rights and freedoms have been suspended. Competence allowing arbitrary and violent acts have been entrusted to the police. This point of view, which considers as a threat not only armed groups and states, but also individuals and collective civil demonstrations, broadens the concept of national security. Thus, application of the state of emergency becomes the new normal. Among this new normal, in particular, the emergency decree laws, which the executive makes frequent and generally abusive use, became instruments in the hands of the government to take measures that it wishes to escape from the rules and the pre-established control mechanisms. The most substantial reform of the 82 constitution in Turkey concerns the exceptional periods. It considerably multiplies the basis for declaring a state of emergency. During this period, the Council of Ministers has the power to regulate all matters relating to the state of emergency with the decree laws that it will adopt. Besides, the limitation of matters which might be the subject of an ordinary legislative decree does not apply to the decree laws for exceptional periods. In that case, the executive body, with the emergency decree laws, will be able to regulate all the matters which it considers necessary. Even will be able to limit totally or partially the enjoyment of fundamental rights and freedoms. Also, certain limitations made to the exceptional decree laws, such as matters related to state of emergency, or insofar as circumstances require, lose their effectiveness due to their judicial lack of control, because these decree laws are exempt from control by the Constitutional Court, but also by other existing channels. Even if the political control of the parliament is planned, in practice it's only a formality, because in the existing political system, the party in government holds the majority in the parliament. In this study, some aspects of the situation in Turkey will be compared with France, taking into account the considerable influence of the French system on that of Turkey. We can briefly observe how the same concept is received by similar legal systems in different countries. The first constitution of the Ottoman Empire was promulgated in 1876, and it was inspired by French constitutions. The current Turkish constitution shares similarities with the French constitution of 1958. For example, the Articles 3 and 10 of the Turkish constitution concerning the principle of indivisibility and the official language were inspired by the first article of the French constitution. For a more in-depth analysis, it will be useful to study in two separate titles, the adoption and the control of these emergency decree laws, because there are essential points to underline in the two stages. I will start by the adoption of the emergency decree laws. This adoption poses two significant problems. First, it contradicts the Constitution and the Convention on several aspects. Then, what's worrying is the fact that no mechanism for monitoring these decree laws is operational during the period of the state of emergency. On the one hand, the constitutionality of most decree laws is questioned for their form, and on the other hand, the measures taken by most decree laws are neither compatible with the Constitution nor with the Convention. The rule which is the foundation of the measure is an unpredictable rule. In the legislative decree, it is specified that appeals are made against measures taken within the framework of a legislative decree concerning persons on whom there are reasonable doubts that they have an affiliation, a link, a membership or contact with terrorist networks or groups or entities that operate to the detriment of national security. On the other hand, in none of the decree laws is it explained what it is to be understood by groups or entities which behave to the detriment of national security. However, the form of this decree law is not the only problem that must be underlined. First, in the Article 120 of the Constitution, it is stated that the measures required by the situation must be sought with the aim of proclaiming a state of emergency. Then, another constraint is to respect the obligations deriving from international law. These obligations must be sought, first of all, in the Convention, especially in its Article 15. On the other hand, most measures are far from respecting these criteria because they are massive and generalized sanctions. As for the duration of these measures, according to the last sentence of the Article 15 of the Convention, there is a time limit. These measures are provisional and limited by the duration of the regime of the emergency state. On the other hand, we note that most of the measures are intended to have their effects in the long term, beyond the end of the state of emergency. Now I will talk about the complete lack of control of the emergency decree laws. The control of these decree laws is carried out in two main stages. Firstly, it is the declaration of the state of emergency and the control carried out by the parliament on this decision. Decree law of state of emergency cannot be subjected to a review of constitutionality according to the Article 148 of the Constitution, contrary to ordinary decree laws. This prohibition renders the constitutional limits ineffective and insignificant, because it will not be possible to control whether the decree law exceeds the limits established by the Article 15 of the Constitution, and the guarantees posed by these articles will have no practical and valuable effect. The decree law may go beyond regulating fundamental rights and freedoms. It may be possible that fundamental rights are limited by the executive. Secondly, all areas that are supposed to be regulated by law can be regulated by decree law. Thirdly, due to the impossibility of monitoring emergency decree laws, several modifications can be made in the legislative field, and the immunities of judges can be waived. So the effectiveness of the entire constitution can be weakened or destroyed. We can criticize the interpretation of the court, which supports the lack of control of decree laws, and hope for a new reversal in the name of the effectiveness of the constitution. In the same way, the prevailing doctrine supports the possibility of control of these decree laws, at least in the case where they will endanger the hardcore of the fundamental rights. In the second party, I will talk about the control of these emergency decree laws. We will examine this control by analyzing the ineffectiveness of the domestic remedies. This absence of effective domestic remedies is manifested not only by the ineffectiveness of existing instances, but also by the Commission for the Review of Measures taken during the state of emergency, which was created in 2016, precisely to offer a new effective way to victims who cannot find satisfaction by other internal legal remedies. I will start by the neutralization of domestic remedies against emergency decree laws. The government has blocked remedies against the measures taken under the state of emergency. The Constitutional Court refuses to exercise control over the decree law of the state of emergency by complaining of being engorged by the vast amount of appeals. The Council of State, for its part, refers the applicants to the administrative courts concerning appeals against these measures, which paradoxically are deprived of deciding on these measures. Consequently, the review of constitutionality is the only review that can be made regarding these decree laws. In Turkey, the Council of State has no jurisdiction to review the constitutionality of a legislative decree. If we take into account the fact that the Council even refuses to monitor ordinary legislative decrees, considering that it is not competent, it is obvious that it will refuse to recognize itself competent concerning emergency decree laws. If we analyze the role of the French administrative judge, it is, under the state of emergency, is essential. It is a body overseeing a large number of actions carried out by the administration during this period. However, it is necessary to moderate the effectiveness of the controls exercised by the administrative jurisdiction. First, we can question the effectiveness of the remedy for excess of power in an emergency. When the administrative measure has an immediate effect and is very limited in time, these remedies have no effect. The average processing time for applications before the judge of the excess of power being 1 year, it becomes uninteresting to request the cancellation of this liberty restricting measure when it is no longer opposable. There are emergency interim proceedings before the administrative court, making it possible to compensate for the slowness of the action in excess of power. But these procedures, in particular the interim proceedings for freedom, are insufficient to guarantee the right to an effective judicial remedy. We can also mention the lack of the effective control of administrative search by the administrative court. As for the French Constitutional Council, on the basis of the Article 61 of the Constitution, it used all the tools at its disposal within the framework of its control ex post. The role of the Council is to ensure that a breach is not disproportionate and that the legislator has in fact provided the necessary guarantees to regulate this measure. It censored unconstitutional provisions, it made reservation of interpretation, and used its power of modulation in the time of its declarations of unconstitutionality. It even noted ex officio a plea which had not been raised by the parties in their priority question of constitutionality. And in the last part, I will talk about the establishment of the Commission for the Review of Measures taken during the state of emergency and its questionable effectiveness. This commission is established in Turkey after the state of emergency. The commission is far from the standards and criteria laid down by the case law of the European Court of Human Rights and by the Venice Commission. There are two types of major problems concerning the work of the commission, and we can start with those which relate to its functioning. According to the first article of the decree law establishing the commission, it consists of 7 members, 3 of whom are appointed by the Prime Minister, 1 by the Minister of Justice, and 1 by the Minister of Internal Affairs, and 1 by the Council of Judges and Prosecutors. The authorities appointing the members take these decisions themselves, and the situation highlights the fact that the principle of independence and impartiality are ignored from the beginning. On the other hand, administrative and judicial bodies continue to direct appeals to this imaginary commission, which is struck by inertia. If we count the numbers, the commission will be able to complete its work in 2 years if it could give the result of 250 files in a single day, which is impossible in practice. According to Article 12 of the Legislative Decree, the staff who will work as rapporteur is composed of civil servants who are hierarchically dependent on the Prime Minister. So this staff has no assurance. The fate of their functions and their decision-making skills depend not on the Commission, but the Prime Minister. The other criticized point concerns the nature of the Commission's decisions. First, the decision is not an annulment. Even if the first measure is declared illegal, it is not deemed to be annulled. This is why we cannot speak of a restoration of statu quo ante. Secondly, the measure which causes harm to the person is not the decision of the Commission, but the measure referred to by the legislative decree. Jurisdictional procedures are not open concerning measures emanating from a decree law of state of emergency. This is to say, victims will not be able to have their considerable material damage resulting from illegal measures compensated through the Commission. In the Venice Commission, it was stressed that the ad hoc mechanism which was to be set up should individualize the files of each applicant. To achieve this objective, the mechanism must be able to comply with the principles of a free trial, analyze specific evidence, and make reasoned decisions. In the present case, however, neither the Commission nor the possible means of appeal against the decisions of the Commission is capable of satisfying this criteria. To conclude, we have seen that in Turkey, decree laws constitute a fundamental tool for the executive during the state of emergency to govern. Nevertheless, we have tried to demonstrate that the adoption of these decree laws goes beyond the legal framework, thereby destroying the control mechanisms. We can say that the presence of the state of emergency and its constant prolongation are strongly linked to decree laws. There is therefore a political intention in what we observe with the suspension of the law. In France, even though the state of emergency ended 2 years after its establishment, it is given way to laws. We can talk about 2 laws. A law strengthening the fight against organized crime, terrorism, and its financing of June 3 to 2016, and the law of October 30, 2017, which reinforces internal security and the fight against terrorism. According to Professor Paul Cassia, the state of emergency has shown that these preventive police measures, based on the supposed dangerousness of an individual, were extremely restrictive of individual freedoms and totally unsuitable for preventing a terrorist attack or a serious breach of public order. Regarding the law of 2017, it strengthens administrative powers for the purpose of preventing terrorism and contains measures such as the strengthening of border controls, the fight against radicalization, and the setting up of search that can be accompanied by documents and data entries. This law is widely criticized for its permanent establishment of a state of emergency in France. Thank you for listening.
Thank you, Çetin, for this appreciable paper on a notion that is provoking the present debate, the notion of emergency, and especially with respect to the counterpart of the state of exception. So the very distinction and the normative impulse to the proper definition of the state of emergency as a counterpart of the state of exception is central in the present debate. So other questions, suggestions, comments? There is no one. No, I see anyone.
Thank you very much.
Thank you. So we can move to the last speaker, who is Simone Pitto from the University of Genova. And Simone is talking about fighting against climate change in court, recent cases and critical aspects of public interest litigation against climate change. So Simone, the floor is yours, please.
Thank you for the floor. And firstly, I would like to thank the conference committee for organizing this interesting event, despite all the difficulties of the moment. Actually, it is my second YCC, and it's really nice to have the chance to have it in Italy this year. So I hold a PhD at the University of Genova in constitutional law, and I practice as attorney in Italy. And the paper I would like to present today aims at conceptualizing climate change litigation within the category of public interest litigation, which is a well-established legal category, although very debated by and among legal scholars. Indeed, in the last decade, several lawsuits around the world were brought towards public authorities by citizens, NGO, groups of pro bono lawyers, in order to denunciate in courts omissions of governments in adopting proper measures to prevent the consequences of climate change, in compliance, in many cases, with international law provisions. So the purpose of the paper, which for the record is not yet published, so I will welcome very much all of your insights and suggestions, would be to understand the main threats of climate litigation, investigate whether climate change litigation may fall actually into the definition of public interest litigation, or simply it represents something else and something different. So to do so, I would like to briefly point out some methodological and theoretical remarks in order to properly limit the field of my research. My hypothesis, what I'm basically interested in, is to investigate the main characteristics of climate change litigation, conceptualize in general public interest litigation and climate change litigation as a particular kind of strategy and technique to guarantee certain rights and these interests, especially collective interests, and understand also their possible impact on legislative process. Finally, another purpose would be to analyze possible criticisms of such kind of litigation. Thus, I will not focus too much neither in the merits of the cases that I will recall, nor in the contents of human right to climate or correspondent obligation of the public powers, as I am more interested in the public interest litigation and climate litigation itself as a technique, a strategy of guarantee of rights. I see that a colleague instead, Fontana Rosa Fiore, presented a paper more consistent with such topics, and I regret I was not able to follow her presentation, but it's not the core of my paper. I would start individuating the main traits and main characteristics of public interest litigation, which is a well-known category of strategic lawsuit, which is aimed at guaranteeing collective interests, contributing with the final purpose of contributing to foster a social change. First definitions were individuated by Professor Chase in the late 60s from Harvard Law School. Professor Ashkoff more currently especially wrote about this topic. Professor Ashkoff from NYU Law School. Such type of litigation developed in the common law tradition, especially traditionally from the Supreme Court of the United States case Brown versus Board of Education, dated 1954, which is pretty known case, as many of you shall remember. It stated that the racial segregation in school violated the Constitution. Not many of you may remember that it was a class action actually brought by Brown, the plaintiff, other families of students, which were supported by civil rights organization, the National Association for the Advancement of Colored People. So it is important to keep in mind this element that public interest litigation was born in respect to the civil movement rights, let's say, in strictly connected with the stare decisis principle, in order to give voice to instances that lacked of representation at the time. The main goal at the time was actually to obtain a binding precedent to be extended to other cases. However, it is not easy to define public interest litigation. Among law scholars, it has been defined as a school of jurisprudence, a technique of citizen activism, and a tool for the guarantee of certain rights and interests. We may, however, try to point out the main typical aspects of public interest litigation, which may be resumed in the fact that it is litigation of groups, public in general, indeed common and similar interests that are gathered together, and such interests, moreover, have to be public interests and not just private or pecuniary interests in the claim. Second element is that it's a form of strategic litigation. So it often aims at obtaining a result that may be extended with the ultimate purpose of fostering a social change. In other words, it's important to bear in mind that the outcome of the litigation, in the intention of plaintiffs at least, is suitable to produce consequences other than the ones related to the parties involved in claim. This aspect also is deeply linked with the nature of common law and the stare decisis doctrine, as I said. Although public interest litigation, we have to say, is widespread around the globe, also in civil law tradition, legal systems. The final aspect is that public interest litigation is directed towards public authorities, aiming at objecting that acts, or more often omissions, of public entities contributed in violating human rights or public interest. As I said, public interest litigation is also quite a debated category of lawsuit, which raises criticism somehow. First common critics is the lack of effectiveness to achieve actual results of such kind of of litigation. But the more the argument, the critic, which is more often presented, is the negative impact of judicial activism, which is triggered by public interest litigation on the separation of power principles. In view of those elements, it seems not surprising that public interest litigation developed in certain matters in which individuals' private interests are just part of a broader holistic dimension of the interest at stake. For sake of example, we may recall environmental law and food law as matters in which such kind of litigation has developed. But an interesting application of public interest litigation may be appreciated also in climate litigation. So climate change law, we have to say, is a recently pretty studied and almost consolidated legal discipline, especially under international law, although climate change litigation appears to be a more recent product. What we refer to when we talk about climate change litigation, well, it is often litigation which is brought by individuals, NGO, and pro bono lawyers towards public authorities, arguing violation of certain duties and rights which are connected somehow to climate change prevention. In order to try to establish some points for my research, I started from with an empirical approach, let's say, from some data gathered by a recent study of Graham Research Institute of London School of Economics, dated July 2019, which has registered around 1,300 cases brought as of 1990 up to today by individuals, again, NGO, public entities, around more or less 28 countries in the world. You may find actually some interesting data among this study. Firstly, most of the cases held belong to common law tradition, which is not surprising. USA is leading the rank with 1,000 cases. The second element, majority of the countries involved are limited to wealthy or high-income countries, although some cases are also related to medium-income countries, especially the study mentioned the case Legari versus Pakistan. Almost 80% of climate-related cases were brought by individuals and NGO. A short portion was also brought by other public authorities, which is an interesting data to consider. The study, however, does not provide a definition of climate litigation, and it seems a quite challenging purpose also among legal scholars. So again, I would take a more empirical approach, starting from the singular cases brought and trying to point out some general categorization and some general characteristics of this litigation. First distinction, starting from cases brought, that we can make among climate litigation is with respect to the purpose and the tools used. First category, indeed, is litigation to enforce existing legislation, which may be national or international duties, which are actually compulsory for public authorities under national law. We can mention in this case the case Future Generation versus Ministry of the Environment, in which was held in Colombia, in which 25 plaintiffs challenged that it was needed a special constitutional protection, and in order to protect the Amazon rainforest against deforestation, on the basis that Colombian measures had violated fundamental rights, such as the right to a healthy environment, the right to life, the right to health, and food and water, etc., which were envisaged by Colombian constitution. And actually, the Supreme Court in this case delivered a novel judgment recognizing that Colombian Amazon was actually a subject of right. So it is an interesting interpretation in this sense. Such kind of litigation, which is based on actually current and compulsory legislation, is also clearly envisageable just in those countries which have a deeper sensitivity for protection of nature, which often envisage a constitutional protection of the environment, such as South American legal systems. Another similar case in this category was brought in 2015 in Belgium by ONG Limatzak VZW, alleging the violation of the Article 23 of the Belgian Constitution by Belgian authorities for failure to comply with the reduction of emissions from levels envisaged in 1990, and also in view of violation of EU law provisions and the, as I said, constitutional provision on sustainable development. This is still a pending case, and judgment is expected for fall 2020, but again, it envisages a violation of constitutional rights. In other cases, it was presented a violation of international law provisions. A singular case in this sense, it was held in France among a public initiative called Notre Affaire à tous, and the name of the initiative was L'Affaire du siècle, which was brought in 2018 after a 2 million people signature petition held in many social media in France. In this claim, it was argued that violation of international provisions that were compulsory for France, such as the United Nations Convention of Climate Change of Rio, especially the objective to achieve the stabilization of greenhouse gas concentration, and the Paris Convention on Climate Change dated 2015, and the Paris Agreement ratified by France in 2016, as France had failed to contain the limits of emission in order to reach up to 1.5 degrees. Another category that we can study in these cases is litigation cases aimed at increasing level of protection, so going beyond current legislation. We may call in this perspective the well-studied Urgenda Foundation versus Netherlands case, which was brought in 2013 before the District Court of The Hague, in which plaintiffs asked for obtaining a serious reduction program of the emissions by the Dutch government in the range of 40% within 2030. So a broader result than the one established under international law as well as European law. In this case, also were some international law arguments, as the no harm principle. Indeed, states shall not cause damage to people or other states. And another international law argument was the joint liability of states in environmental and climate issues based on the Kyoto Protocol. In this case, in December 2019, the Supreme Court of the Netherlands confirmed the judgment of the Court of Appeal, which upheld the demand of the plaintiffs, affirming that each state should be liable for the health protection of citizens, and climate change have an impact on people and human rights of people. Hence, each state should be liable for the emissions produced by the state itself. So I profile cases such as Urgenda and Ljubljana cases that I recalled have influenced similar cases filed in other jurisdictions, such as the case Friends of the Irish Environment versus Ireland, challenging Irish government's national mitigation plan has failed to comply with international law provisions on reduction of emissions. So briefly, we can speculate on some of the main issues triggered by such kind of litigation. The first issue is the impact on human rights, because it's interesting to appreciate that many of the climate litigation allege that actions and omissions of public authorities to adopt proper measures to prevent climate change had the effect of affecting human rights. Also, other cases presented argument in which violation of climate change prevention had the effect of violating other human rights. So there was an indirect violation of human rights. Another interesting characteristics of such kind of litigation that we can speculate on is the role of experts and civil society. For instance, in the Ljubljana case held before the Supreme Court, the Ninth Circuit Court of Appeal in the United States, there was a huge participation of experts and amici curiae, members of the United States Congress, prominent experts in scientists in a variety of fields, presented in the case amicus curiae briefs sustaining the claim of the plaintiffs. Another interesting case in this perspective is the case which is to be brought in Italy within the initiative Giudizio Universale, universal judgment, in which promoters of the case are professors of law, lawyers connected to an NGO, which support the proposition of the climate lawsuit. In this case, it's interesting to notice that social engagement came before the writ was even lodged before the court. Many conferences were held around Italy, and the remarkable media program was developed to support the initiative. And also another interesting element of this litigation is that scientists and experts actually took part in the drafting of the pleadings in the case and the drafting of the data and supportive document that should be disclosed in this trial. So it's an interesting application of a technique of collective writing of pleadings that has the purpose to gather more supporters and bring civil society knowledge into courts. So I shall conclude as time is running out. Is climate litigation a form of public interest litigation? Is it something different? We may say that it has a lot of elements in common and similar methodologies, although it seems that somehow the focus has changed, as traditionally and more traditional cases of public interest litigation had a precise aim, especially in common law systems, which was to create a binding precedent to be extended to other cases. Instead, climate litigation and environmental litigation as well appears more interested in involving people to support policies against climate change as first purpose, also through the participation of claimants and experts in and out of court. Thus, it seems more somehow a strategy of carrying on climate policies, contributing to raising the attention of people and consequently to raise the attention of governments and parliaments as the matter has become more popular. So the ultimate goal, in other words, is to create a change, let's say, in the indifference of legislators towards the adoption of proper measures of protection and climate change prevention. We can speculate, of course, on the critical aspects. As I said, there's not much time for that, but legal scholars argue that a total judicial activism, which is triggered in these cases, may be damaging and may jeopardize the principle of separation of power. And also, in many cases, it was alleged the violation of international law provision, especially related to the European Charter of Human Rights, Article 2 and Article 8, with the indirect violation of climate human rights, although the European Charter of Human Rights does not include a precise reference to such topics. So personally, I don't see I don't agree so much with this criticism, as it has shown that international provisions on emission reduction often lacked of effectiveness, and the arguments based on human rights are just more effective than other arguments. It's not also something new, as public interest litigation has a significant tradition over the years. But I would like also to recall some positive aspects, and then I conclude, of such kind of litigation, which, as I said, has become somehow a way of carrying on climate policies involving people and bringing governments to take more seriously climate action. A positive effect is, of course, the participation of civil society in and out of courts. And the actual results achieved, for instance, in the Urgenda case, are remarkable to appreciate. As they further to the judgment of the Supreme Court, the Dutch government actually started a serious review of climate and environmental policies, such as no new carbon plans, new environmental taxes, incentives for green activities. Also in France, with the Notre Affaire Tous initiative, there were several meetings with France's Prime Minister, Edouard Philippe, in 2019, between the ONG that promoted the initiatives, and also with Emmanuel Macron, discussing on the topic and raising the attention. So there are some positive aspects beyond critical issues raised, and it seems an interesting phenomenon to speculate on. Thank you very much.
So thank you, Simone. And from my side, I could say a particular mention to the structure of your paper and to the well-organized legal arguments and discourse. So very clear, very neat, and so my personal compliments for this. So the debate is open. Professor Zeno Zenkovic, please.
Just to mention, but this came out on Dr. Fontana Rosa's presentation of last week, 2 weeks ago, just to mention among the cases, because as I imagine that Dr. Pitto knows it, of the Swiss Federal Court on Klimaverein Signorinen. I'll send the link, not the link, just a mention to everybody, which has instead rejected this the claim on climate change. And the second point that I want to just mention, as Dr. Pitto mentioned, the issue of separation of powers. There's a decision by the Italian Constitutional Court concerning the Ilva, the steel factory in Taranto, which on a conflict of powers raised by Parliament against the criminal judges of Taranto, said that a problem of emissions control and environmental protection, that was an issue. The decisions had to be taken by government and regional and health authorities, and not by the judges. Just to point out that this is interesting, shows that the issue of separation of powers is a significant argument, which I would agree, because judicial activism gives a lot of, it's a way of great promotion, publicity for certain very vocal groups, but then it's a way, it doesn't come out to anything, but they are on front page and they go on TV and so on, but they and obviously the courts, but I don't think this is what the courts are, should somehow, this is not the business of the courts, it's the business of Parliament and of government, but this is my personal view.
Thank you for your insights. Actually, I reviewed the Swiss Federal Court, and there are actually a few of cases in which the demands of plaintiffs were dismissed, and one of the main issues and the main objections raised was actually the separation of power, especially in the Urgenda case. The Dutch government insisted a lot on that. With respect to the Ilva case that you mentioned, it's really interesting in my view, and I remember while you were talking, a judgment of the Italian Constitutional Court, I think it's dated 2015, in which it was mentioned an argument that I would say it's not so often, not enough often mentioned in climate litigation case, which is the need to have a balance between different rights at stake. I mean, environmental protection and its consequences on human health, of course, but also the need to protect the right to the economic initiative and to, well, factories level of production, of course, the occupational levels, which was a very interesting issue in the ILVA case. So the focus should be always on the need to balance those rights, also with respect to climate issues, I believe, as the Constitutional Court of Italy suggested in the ILVA case. As per the separation of powers argument, I agree on some of the criticisms, and I would say that differently than the more traditional cases of public interest litigation, climate change litigation, in my view, I would say, has the benefit of trying to move the matter into parliament. So, for instance, the case which is to be held in Italy and the case held in France, as I said, started with a proper campaign, media campaign, with meetings with the government, with the ministries, and with claim notice letters before starting the actual claim in court. So the benefit, let's say, with respect to the separation of powers principle of this new kind of litigation is that the first goal is to move the matter in the parliament, to force the parliament to adopt proper measures and to face the topic. So the litigation is residual, let's say, somehow. It's a way to gather the attention, I would say, at least in the intention of some of the promoters of the initiative, which poses, in my opinion, less problems than on the field of separation of powers, as in the stricto sensu legal argument before a court, it may bring, in some cases, I mean, to the dismissal of the demand, as several cases showed. Thank you for your insights, anyway.
So, other question? Antonio Baraggia, please.
Thank you. I have a question because I studied a little bit the case of Chevron Texaco versus Paraguay. And this is a very interesting case because, as you mentioned, the Constitution of Paraguay deserve a big protection to the rights of the nature. And in fact, the Constitutional Court, after a long saga, condemned Texaco for having violated the nature rights. But the decision of the Constitutional Court was overruled to a certain extent by an arbitration tribunal. So this is an interesting case in which constitutional level, the private level are intertwined, and in the end we saw that the constitutional protection was quite weak, because in the end the final word was given to this private arbitration tribunal. So I'm curious about your thought on this.
Thank you for your remarks. It's a really interesting part of climate litigation that I forgot to mention, actually, which are the claims addressed to private entities. There are many cases, actually. I did not focus on that because I was more interested in climate change litigation as a form of public interest litigation, which is always addressed towards public authorities. But it's really interesting. And the arbitration clauses which are included in many contracts of stipulated by national authorities are always a triggering and sliding floor, let's say, because in many cases the provisions of the states to protect some natural resources of these countries were declared as not compatible with the contracts stipulated. So arbitration is a really interesting perspective of such kind of litigation. And you mentioned another interesting element, which is the effectiveness of many of the provisions related to climate change. I said that in many cases, human rights-based argument had the effect of having more chances to conduct to the uphold of the case, but somehow in other cases, international law-based argument that were more successful. So in constitution in the area of South America, and especially constitution which are inspired to the principle of the buen vivir, for instance, like Colombia, like Paraguay, like Ecuador, they have a lot of constitutional provisions on the protection of the environment, the rights of indigenous people connected to the environment, for instance. But often such kind of constitutional provision are lacking of effectiveness because they lack of effective remedies towards with respect to violation of such rights. Although there is a pretty developed sensitivity among these countries with respect to these topics, and I forgot again to mention an interesting decision, which was an interesting meeting which was held in May 2020, so last May, at the Inter-American Commission of Human Rights, in which it was highlighted the deeper impact on the rights of vulnerable groups of climate change. And before the Inter-American Commission on Human Rights appeared representation from a number of civil society organizations, which argued that climate change had a huge impact on the rights of inherent civilization people or indigenous people of the Amazon region, for instance. And such population are the most affected by such kind of phenomena, and also lack of remedies to denunciate these violations. So there is a lot of sensitivity. I don't really know if there are actual effective remedies in all of these cases to before violations of such rights. I actually doubt about that in some cases. But thank you for your interest.
Thank you. Other comments?
No, one.
Please.
Okay. Just two questions. One is about stare decisis and the other about balance of interests or of rights. Well, as long as you mentioned stare decisis, don't you think it is more of an hindrance than a help in these cases? I mean, the matter with Brown was precisely the presence of Korematsu and Plessy. It was very hard for the court to bypass those precedents. And besides, the court would unsuccessful to establish a real general principle, so that we need indeed a legislation, Civil Rights Act of the 60s. So for the American side. And on the European side, well, I want to know your opinion. Is the balance of interest not a blurring factor, rendering everything unforeseeable? Especially in the version made by President Kattavia recently, which is just anyway a copycat of German case law on the point. Because according to her, the equilibrium between rights in our constitution is always dynamic. Being always dynamic, it is every time for the court to decide ex post which was exactly the equilibrium. So it is just a way to assert the power of the court on every act by parliament, not only the government. And so I think it can be very disturbing in the legal system of constitutional reconstruction. So just this, thanks.
Thank you for your remarks. Well, as per the stare decisis principle, I agree with your remarks, as I believe that the Brown case, which was the traditional case, as you said, showed that it was not sufficient to bring the matter in court, and that's the reason why before, while I was we were talking about the other questions, I recall that, in my opinion, one of the benefits of climate change litigation is to bring in the matter into parliament, to move people, to move government, to have a serious discussion on these issues, because it has to start from there, I believe. I cannot, I have to say that in many cases, arguments by courts seemed forced to the extent of avoiding somehow maybe criticism with very popular issues, and anyway, on the field of stricto sensu right-based argument, it seems forced in somehow. So I think it's important to start from parliament and to government issues. Another interesting topic that you mentioned again with respect to balance of interests is, and it's connected to this aspect, because starting from an initiative in the parliament, so leaving to the legislator, which is bound to the respect of constitutional limits, and parliament are also subject to, parliament acts are subject to constitutional courts control, for instance. Parliament may make a ex-ante balance of interest, and then in court we can proceed to limit the analysis to the case-by-case balance of the interests. So this is less tricky, I think, and exposed to less criticism, because ex-ante balance is always more difficult in my view. So in the precise case with the elements of each case that plaintiff shall bring to the attention of the court, it is easier to understand which of the interests shall prevail in the case. While it's, on the one hand, it's hard for the judge to do so in the lack of legislative measures on the topic, and on the other hand, it's hard for legislator to do that on a ex-ante basis. So I agree with the need of both. So ex-ante balance, more in general terms, by legislators to avoid excessive judicial activism, and a stricter case-by-case balance in court on the basis of the principle established by the law. Thank you.
So other remarks, comments, suggestions? No. So the session is concluded, and sincere and touched thanks to all of you for your active participation. I hope to see all of you sooner as possible. And I remember to all the present that the next sessions of our conference will be tomorrow afternoon at 6 o'clock. No, 4 o'clock. So
if I must I just want to add, tomorrow afternoon, 4 o'clock, from 4 to 6 o'clock, Chair Professor Monateri. The topic is systemology, and we have a very wide and international panel mostly from all around the world. So just to point out that this is a very interesting topic and quite correctly chaired by Professor Monateri.
Okay, thank you all. Bye.
Thank you all. And,
bye bye. Ciao.
Ciao a tutti.
Bye.
Ciao a tutti.
Ciao.